Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for steno dictation and steno related contents. Be ready for the PA passage for Supreme Court examination. इस डिक्टेशन का लिंक आपको नीचे डिस्क्रिप्शन बॉक्स में मिल जाएगा. Be ready. Without any stop. There can be no attributes more important than the life and liberty of a citizen in a civilized society. Article 21 of the Constitution of India provides that no person shall be deprived of his life and liberty except in accordance with the procedure established by law. The imposition of death penalty on a convict is the procedure established by law which is subject to appeal and review. After exhausting all legal remedies, a convict has an option to seek remedy under constitutional scheme of pardon by moving a petition for mercy before the President of India or the Governor of a state as the case may be. Based on the analysis of the checkered history of the constitutional scheme of pardon, the author of this paper peeps into the concept of pardon and the present day crusade to streamline the benevolent provision. Pardon is an act of mercy or clemency by which a criminal is excused from a penalty that has been imposed by a court. It wipes away guilt and makes the person who committed the crime as innocent as though a crime has not been committed. A pardon may be conditional or absolute. A pardon is an act of grace proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for a crime he has committed. It affects both the punishment prescribed for the offence and the guilt of the offender. In other words, a full pardon may blot out the guilt itself. It does not amount to an acquittal unless the court otherwise directs. Pardon is to be distinguished from amnesty, which is defined as general pardon of political prisoners, an act of oblivion. As understood in common parlance, the word amnesty is appropriate only where political prisoners are released and not in cases where those who have committed felonies and murders are pardoned. The power to pardon is a constitutional responsibility of greater significance. The Constitution of India vests this power in the head of the state. Article 72 of the Constitution of India invests the President of India, and Article 161 of the Constitution of India invests the Governor to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person. The provisions relating to pardoning power were discussed in the Constituent Assembly at great length. On 28th December 1948, the issue in question was discussed in the Constituent Assembly. The debate was started by Mr. T. Hussain by proposing amendment number 1286 seeking deletion of clause 3 of Article 59. He opposed vesting of the power of pardon in any authority other than the head of the state. In this background of facts, Articles 72 and 161 were introduced in the Constitution to cover the former royal prerogative relating to pardon. Article 72 confers upon the President power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence enumerated in clauses A to C to Article 72 1. Article 72 states that the power conferred by law on any officer of the armed forces for the purpose of suspending, remitting, or commuting a sentence passed by a court martial would not be affected by the power of the President contained in Article 72 1A. Article 72 3 further provides that the power of the President to suspend, remit, or commute a sentence of death under Article 72 1C would not affect the power of the Governor of a state to suspend, remit, or commute a sentence of death under any law for the time being in force. Likewise, Article 161 of the Constitution confers upon a governor of a state in respect of any offence against any law relating to a matter to which the executive power of the state extends. The power under Articles 72 and 161 of the Constitution is absolute and cannot be fettered by any statutory provision. The necessary sequel to this logic is that, notwithstanding any statutory provision, the President and the Governor continue to exercise their power as the case may be on the advice of the Council of Ministers. A plain reading of the above provisions makes it crystal clear that the power conferred upon the President of India under Article 72 is of widest amplitude in comparison to the power conferred upon the Governor of a state. Article 74 within bracket 1 of the Constitution states that the Council